as you know, we're here to talk about caveats tonight. They're interesting weapons, perhaps. They can be used as a weapon indeed. But there are a number of things that you need to know. So I'm a property lawyer and my name is Peter Barakate. And my partner on the right there, on your right, my left, is Gavin Stuart. He's a commercial litigator with extensive experience in real property matters. And between us is Miles Condon SC, who also has significant experience in dealing with caveats before the court. So the first thing that you need to know if you are considering putting a caveat on title to somebody's property is that you must have an interest in land before you can do that. You can only lodge a caveat if you have a proprietary interest in land. Now, when I say proprietary, I mean an interest that attaches to land, and that can be distinguished against an interest that arises through contract or through a personal right, or even through statute that doesn't also confer an interest in land. If you are seeking to lodge a caveat on title to protect your interest, then that caveatable interest must exist at the time that you lodge the caveat. Now, with caveats, there is a particular form that's been sanctioned by LRS that you must fill in, and it's got certain details, and we will look at that through the questions and answers that we have tonight. There is a statutory declaration in the caveat where you acknowledge that you have a proper caveatable interest in the land to the best of your knowledge and belief. So it's a serious thing to complete this form, and if you don't swear the declaration, then the caveat will not be accepted by LRS. The caveat takes effect as soon as it's lodged. So it's not like another dealing with title, a mortgage or a lease or an easement, for example, that has to be registered, registration following lodgement. In the case of caveats, as soon as it is lodged, it will be effective. And what the caveat does is you'll find that there's a notification put on title, and the caveat will operate as a statutory injunction. So it will restrict the ability of the registered proprietor to deal with the land. And by dealing, I mean selling or procuring the registration of a lease or a mortgage or an easement. So if you're strategic and if you have good cause, you can use a caveat to frustrate the ability of the registered proprietor to deal with his or her property. So let's unpack this a little bit and discuss what's an interest that is sufficient to support a caveat, because there might be a whole heap of interests, but not all of them are sufficient to support a caveat because not all of them are interests in land. So if you're a purchaser under a contract for sale, then that interest will enable you to lodge a caveat. Likewise, if you've got a call option, that will give you an interest to support a caveat. Or if you're the vendor of a property under a put and call option and you have a put option, then that put option will give you an interest which will support a caveat. Likewise, if you're an unregistered second mortgagee, that interest will support a caveat. And as I mentioned a minute ago, in relation to leases, if you are a lessee or if you have an interest under an agreement for lease, then likewise that interest, being an interest in land, a proprietary interest, will be sufficient for you to lodge a caveat on title. Also with easements, if you've entered into an agreement with, say, your neighbour to give you an easement over his property so that you can drive across it to get from your battle axe block to the road in front, but it's going to be some time before you get the easement because you've got to prepare a survey plan, then you can caveat the title to protect your interest. Let's contrast that to mere contractual rights, which don't necessarily confer on you an interest in land. You can't conjure up a caveatable interest by entering into a contract and by agreeing with the other party that you can lodge a caveat over their property. These caveats are called bootstrap caveats because they're about as effective as trying to pull yourself up by your bootstraps. You won't get very far, the caveat won't be very effective. So although a mere contractual right that's not coupled with a proprietary right won't give you a caveatable interest, it may be that you can expressly or impliedly draft in the contract a proprietary interest to secure your rights under the contract. And if you do that, then you will be able to lodge a caveat that you can sustain on title. And Miles will say just a few words about this in the context of you drafting into a contract a charge over land to secure the repayment of a sum of money that's owing, maybe under a building contract, for example, or a mortgage over land where you're looking to secure the obligations under a guarantee.
It's very important from the court's perspective that the interest in the land be identified. And you'd be surprised to know that lawyers draw very fine homespun distinctions about what does and what does not give a capable interest. It's important you go to your solicitor to get it drafted properly. As Peter says, if you insert in the contract a mere right to lodge a caveat, the courts will usually say that is not sufficient to give a capable interest. If you add a few twists to it, if you say, by this clause I acknowledge I have a capable interest and I can lodge a caveat, or you mention security in some form or another, then that may convince the court that you have more than simply a right to lodge a caveat, but what the caveat's in fact doing is securing an interest. So the courts will look at the contracts to see if there's simply more than a right to lodge the caveat. Judges can come to different conclusions about this. There are some formulae which the practitioners know about. It's best you consult your solicitors to try and work out what the formula is. Can I just say this? In some cases, the court looks behind the contract, goes beyond the contract to see what the party's understanding was more informally. Were there discussions before the contract was entered into whereby the protagonists accepted that there should be security in the form of a caveat? That evidence is admissible. It is sometimes used to justify supporting a caveat where the contract is perhaps more ambiguous. The moral is, if you're negotiating a contract and you want to put a caveat in, take a record of what you say with your opponent or the other contracting party. I'm a litigator, I'm sorry about that. With the other contracting party, it may be admissible.
Thank you. That's important because establishing up front that you have a caveatable interest will save you headaches later. So now that we've looked at a number of interests in property which will support a caveat, and then looking at mere contractual rights and perhaps how you can cast them in a way to support a caveat, it's probably a good time to see what isn't an interest that will support a caveat. So if you've got a right of preemption or first refusal, that won't support the lodgement of a caveat because it's merely a contractual right. It only becomes a caveatable interest when the grantor decides to sell the property, because that decision triggers your entitlement to exercise the right and converts it into an option to purchase. Likewise, if you've got a right as a lessee to apply for relief against forfeiture, that will not give rise to a caveatable interest, nor does a licence, and a licence will give you non-exclusive possession of land, so a licence also will not give rise to a caveatable interest unless somehow or other it's coupled with an interest in land. This is important because you want to secure the validity of the caveat. Now, if you, without reasonable cause, lodge a caveat or refuse to withdraw one after being requested to do so, then you may well be liable to pay compensation to any person who suffers pecuniary loss as a result of your actions. Miles, have you had any experience in these sort of cases?
Regrettably, yes. From one of my former clients. The Act allows or gives a right for compensation to a party which has been inconvenienced by a caveat which should not have been properly lodged. As Peter says, half the battle is working out if you have an interest. And the law is quite arbitrary about what interests do and do not create an equal interest or capital interest. Going back to the importance of obtaining legal advice, there's a recent case where the judges in the Court of Appeal split over whether or not compensation should be ordered. The leading judges said that a client who had gone to the lawyer, obtained advice about was there a capital interest, was satisfied upon the advice that there was an interest, relied reasonably upon that advice, could not be sued for compensation. So again, it's important. I appreciate many of you want to do lodge caveats yourself. It can create problems. Sometimes speaking to the solicitor will obviate some of those problems, including a claim for compensation.
Thank you. So now that we've had a look at what does constitute a caveatable interest and what doesn't, we thought that it would be a good opportunity to take you through a recent case study in which we're involved. It started with my office and ended up in court. And at the beginning of the matter, I could see that this was going to be contentious, so I involved Gavin right from the beginning, and it turned out to be beneficial for the client. Our client in that case was a developer, and the developer was a party to a joint venture agreement with a landowner. The joint venture agreement allowed our developer client to assist the landowner to obtain a favourable development consent for the property, and provided that if he did that, then there would be a profit share arrangement arising from the uplift in the value of the property. And the joint venture agreement quantified what the profit share arrangement would be. Well, our developer client got the development consent and it was on favourable terms and it did increase the value of the property. The landowner was very excited about that, but decided that she wanted to keep the value for herself, and she attempted to sell the property without any accounting to our client. So he came to us in a state of distress and wanted to know if the joint venture agreement gave him a caveatable interest to restrain the transfer of the land, and this was really important to him. So, from there, my question to Miles is, do you think that a JVA can give a party a valid caveatable interest in another person's property?
Well, despite the fact you didn't retain me in the matter, I will answer the question. The answer is yes. The right to share in the proceeds of a property owned by joint venture partners, provided the contract is specifically enforceable, will usually allow you to lodge a caveat. I should say this, there's two ways you can answer that question. One is by looking at the profit share and divining from that a right to receive the proceeds from the venture. The second, of course, is complementary. Is there a clause in the contract that refers to a caveat and allows a caveat to be lodged and discloses the purpose of the caveat? But generally speaking, a joint venture will authorise the lodgement of a caveat. Do the judge agree?
We'll come to that.
Yeah, okay.
So as I was saying before, when you lodge a caveat, there's a prescribed form that LRS requires, and and you've got to complete it in accordance with LRS's requirements. So when you're completing the caveat, how would you identify the interest claimed?
Can I just go back and explain why you're asking the question?
Absolutely.
Caveats have to follow a prescribed form, and the regulations to the Real Property Act identify what has to be lodged in the caveat. Courts are fairly generous in amending the terms of a caveat if they think the caveat should be amended to reflect the true position. But one thing the court is firm about is that there is a question that has to be answered, namely the particulars of the estate or interest in land. It is amazing how many times clients, particularly those without lawyers, simply insert equitable interest. That will justify the court in striking down the caveat. Those words don't identify the caveator's interest in the land. No one searching the title can understand what the caveator's interest is. So one has to be a bit more fulsome. So words such as equitable interest of a person who is entitled to an injunction restraining disposition of the proceeds of sale will create a different position. So it's important to draft this apropos of that part of the caveat, particulars of the estate, to ensure the court doesn't strike it down as invalid.
Peter, if I can just chime in there. Can everyone hear me? We've had some interesting situations, factual situations that cut across this question of the interest, but also the identity of the caveator. And one that I was going to mention is in relation to trusts. We had a recent case where there was a charging clause in a deed of loan in effect, and the charging clause was, or the charge was in effect given by the trustee of a trust. But the interesting thing about the case was that the trustee was a company, and the company signed the deed at a point in time before it was the trustee of the trust and before the trust was even established. And we initially took the view that this was going to be a very difficult charge to maintain, and hence the caveat could be attacked on that basis. After looking at it more closely, we formed the view that it was much more finely balanced than that. And the reason for that was that the beneficiary of the trust was a person who had also been the cause of the loans that had been made by the creditor or in respect of which the trustee of the trust was acknowledging. And so there was a continuum between this particular person who had borrowed money and then become involved with the trust. If that continuum was not there, then it may well have been a much harder case for the caveator. But it was a lesson for us, anyway, that a clause like that on its face looks like it may not be maintainable, could give some real teeth to the contracting party in terms of a caveatable interest.
Can I just chime in with something else about development and about the caution one has to have in your contracts when you seek to impose or obtain a caveatable interest. I've seen a case where, I think it's a court of appeal, where the court said your contract allowed you to put the caveat on the land before division, but when it became to be subdivided into individual lots, your interest didn't extend to those individual lots. So as a drafting exercise, where the developer fell down, or his lawyers fell down, its lawyers fell down, was it didn't accommodate the subsequent subdevelopment and the creation of individual lots, which goes to show the precision you need when you draft the contracts to ensure what you are describing accurately covers the present and the future. And you can have caveats over parts of land. It's fiddly, it's a fiddly driving exercise, but it's doable.
And this, for us, is always a significant consideration because it plays into the question of who is going to swear the stat dec. So we don't just, as Peter said, sign caveats. There's a statutory declaration that is sworn, and on knowledge, information and belief, the person swearing the statutory declaration is saying that there is a caveatable interest. So from our perspective as lawyers, the question is whether we are going to swear that that is the case. And if we have uncertainty around that and we're unable to really clarify the true situation and satisfy ourselves that there is a caveatable interest, we may then need to have a discussion with the client about whether we are prepared to even swear the statutory declaration, and the client may say, well, I'm prepared to do it, and well, that may be the case, but we do need to be mindful of that. And then that plays into the concept of compensation being payable if there is a caveat on title and it's not maintainable and there was no caveatable interest and it should never have been lodged and there's some ramification of that. So significant considerations.
Another thing I was going to add to that is that if there's a caveat on title which runs through onto the subdivided lots, and that wasn't the intention, a practical problem that you can have is you've got to get it off the lots where it shouldn't be. And it might, for $143 per withdrawal, sound like it's not much, but if you've got a significant development where there are lots of subdivided lots, it'll add up, and it's fiddly, and there are legal costs involved, so it's perhaps not something that you really want to do. And that is a good point that takes us to looking at what you're doing when you're preparing a caveat, because we're still at this stage where we're looking at how you frame the actual document. And in preparing it, you've got to realise that you should treat it as if it's another dealing with title. So you should always look at the title search, see what other interests are recorded on title, because that may well affect what you want to do with your caveat. Now, I recently had a matter where I was acting for a second mortgagee, an unregistered mortgagee, and that mortgagee was concerned that the first registered mortgagee would sell the property and there'd be nothing left for my claim. So relying on a particular provision of the Real Property Act, we amended the caveat to say that the first mortgagee could not exercise his power of sale to sell the property. And there was, as I said, there was a provision in the Real Property Act that allowed us to do that. And Miles, you have something to add to this, don't you?
It doesn't mean it won't happen because the court has a discretion to set aside caveats, and we'll talk about balance of convenience later, but the court will try and weigh up the interests of the competing caveatable interests to see what is just and appropriate. The short point is just because you put it on doesn't mean it will stay on. But can I just raise one other topic? Because Peter, you mentioned, sorry you keep standing, I have a meniscus problem, so I feel very sorry for you. You say that one of the purposes of the caveat is, in essence, as a form of injunction to deal with dealings. There's a second purpose, which is equally important. If you've got a charge on, which is unregistered, because you have a first mortgagee who won't allow you to register a second mortgage, for example, take your case. But so the loan covenants won't allow another mortgage to be registered. You put the caveat on, and the caveat gives notice to any other financier who might be lending money against the same security. I'll talk about financier. I do work for suppliers of plumbing goods, for example. On a building site, there are a number of such suppliers. They want to have first in time. They want their caveat on before the others. Why? Because when it comes to dividing up the proceeds of sale, you look to the registered interest first, so that the first mortgagee will take, and then prima facie, you look at the time the interests were created. In the eyes of an equity court where I practice, first in time prevails. The first chargee takes priority over the second chargee, the second over the third. Now, because we're lawyers, there's no golden rule, every rule is subject to exceptions. But one of the advantages of putting a caveat on is to signify to all and sundry, I have an interest which takes priority over those that have not yet been registered. So to go back to your example, it may be the case that you know the first mortgagee is going to try and lapse your caveat. And you say, okay, well that's a risk I run. But at least by putting the caveat on, I know I'm telling other potential chargees that my charge takes priority over your charge.
And whilst we're talking about priorities, I may be going a little bit off script there, sorry.
No, it's all good.
I think I started.
While we're talking about priorities and finance, from time to time we do have situations where we are acting for a client who needs to deal with the situation where there may be a first registered mortgagee and a lower order caveat, if I can put it that way, protecting some creditor and that debt may be in issue. And in those sorts of situations, on occasion, the first registered mortgagee can become a little bit difficult, particularly if they get wind of the dispute. And if they then take action to seek to take possession or other steps like that, then an option is to try and take that mortgagee out. And if we're able to arrange that for our client in some way, and the most recent time we tried to do this, it was with, in effect, private funds controlled by the client. The challenge then becomes how you take out that mortgagee and maintain the priority, if you like, so that the caveator who you're in dispute with does not then have a higher order or a higher interest on the register than you do. So having the mortgage assigned would be a way of doing that. But if you can't achieve that, and often mortgagees don't want to do that because they can then be roped back into the whole dispute, it then becomes quite difficult. The issues that we deal with caveats don't just end with the caveats themselves. It also involves looking at all of the interests on the title and trying to manage all of them at the same time through the disputes that we're dealing with.
And in your practice, Miles, in doing this, have you been involved in any cases where you've had an issue with identifying what the caveatable interest is?
Yes, usually it's a sloppy drafting the first time around, and as I say, a common problem is there are many caveats that simply say capital interest, and we know the courts are going to reject that. And that involves then a cost consequence to the caveator and a potential argument that another caveat should take the place of that caveat.
So we're still looking at the moment of preparing the caveat. We've identified the caveatable interest, we're explaining that, writing that in the caveat appropriately. We've done our title searches to see what we've got to deal with. Now we've got a simple matter that's often overlooked, but it's practical and it creates problems in daily life. And that's something I'd like to put to you, Gavin, and that is, in the form that we complete, we have to stipulate an address so that LRS can serve notices on the caveator. What do you reckon we should do in that case?
Well, the safest way to deal with that issue is to use the caveator's address itself. The options are to use that address, the caveator's address, or the solicitor's address. There are some issues in using the address of the solicitors. For instance, if the solicitors move address, then the issue arises of how you notify of that change of address for any caveats that are on title. Or even if the solicitor is running a small practice and the address is unoccupied for a period of time, say over the Christmas New Year period. instance.
Because people never lodge lapsing notices just before Christmas, do they?
No, not as a tactic.
No.
No one would do that.
It'd be quite improper.
So safest way is to use the caveator's address.
And this is important because although the world is changing when it comes to the address for service of notices, they are not being done by email, they're not being done even by fax. They are posted by LRS to an address, and that's why it's very important that you get this right. So one instance where the address for service of notices is very important, which Gavin has sort of just touched on, is where the registered proprietor, for example, sees the caveat on title and wants to get rid of it. And so what he or she does is to commence the process for the caveat to lapse by making an application to LRS, and then LRS prepares a notice and they issue it. So in circumstances like that, Gavin, where the caveator receives a lapsing notice from LRS, what does that actually mean for the caveator?
Well, it means that the caveator has 21 days from service of that notice to approach the Supreme Court, and it would be the Supreme Court, which has jurisdiction in relation to land, to obtain an order extending the operation of the caveat and to have that order registered with the LRS. If those things do not happen within the time frame, then the caveat will lapse, and the legislation says that if a caveat has lapsed, then you cannot lodge a new caveat, a further caveat claiming the same interest. So it's very important that the caveator moves quickly once receiving that notice.
Because it's a 21-day period, and that's 21 days, not business days. So it includes weekends and public holidays, which is why the point was raised about people commencing lapsing of caveats before Christmas, New Year, when everyone's on holidays, can be very effective. Miles, did you want to say anything about that?
I do. Judges, the party, in practice what happens is the party trying to maintain the caveat will go before a judge. And one thing that party has to do through his or her counsel is indicate that you're still within time, still within the 21 days. The 21 days cannot be extended. It's inflexible. And the judge will ask, when was the caveat received? Now, I don't know about you, but in my practice, barrister's practice, even the barrister's practice, a lot of my stuff is not date stamped. And it's quite common for documents to come into a practice or a large company with no date stamp on it. And you can't tell the judge when this document was received. So judges are pretty firm in trying to have some evidence as to when the caveat or lapsing notice was received. The moral of the story is, if you're going to lodge a caveat, you have to put in place a mechanism for properly dating the receipt. As Peter says, it's one of the few communications we have nowadays where letters count. Not email, not facsimile, there's no electronic record of it. It's when it physically hits your desk. Unopened or opened, time runs. Can I just clarify one thing, and I think Gavin was alluding to it. Humans being as humans are, and barristers being as barristers are, we leave things to the last minute. You can't do that with the 21 days. The court used to get, time and time again, people coming up on the afternoon of the 21st day seeking an extension of time. And people do that for decades. And one time a judge found out, if you went back to the Act, you actually had to make an order extending the caveat, having given notice to the other party first. In practical terms, your counsel or your lawyer has to go up about a week before the expiration of the 21 days. So about 14 days in. If you wait to the 21st day to initiate proceedings to extend the time, the judge will almost certainly reject the application. So it's important when you get this lapsing notice to do something about it quickly, because time counts, and we'll get to the process shortly. But what you have to do is file a court process, usually a summons, and an affidavit that sets out why you're entitled to your capable interest. Some affidavits are easy. If you have a mortgage, you annex a mortgage and say you advance money. Some are more complex. Some take time to do. So you have to move pretty quickly on these sorts of applications.
It's worth just repeating the point which Gavin made before as well. It's not just getting the order from the court, but you actually have to have the order lodged with LRS within the 21-day period. So if you get the order from the court on day 19, then you're cutting it fine to get it lodged and accepted by LRS in that time.
And Ben, just before you go, and if I could just pick up on something that Miles said, there are practice notes in the court, the Supreme Court of the equity list, that make it clear that if you are going to approach the duty judge in equity with an application to extend a caveat, then you need to be doing that at least 5 days before the 21-day period expires. And there is a particular list, the real property list, that is run by Justice Stuart every Friday. But you can, and what that list practice note says is that you need to contact the associate to make arrangements to approach Justice Stuart to have caveat matters dealt with. So the courts are mindful that these sorts of applications come on at the last minute, and they try and regulate that. But the reality is that often it takes most of the 21-day period for your client to receive the notice, look at it, send it through, take some advice, think about things, raise funds, and give instructions in order to action whatever the instructions are. So time is always an issue when it comes to dealing with these notices.
So if the caveator seeks an order from the Supreme Court to extend the operation of the caveat, Gavin, can you tell me what that means, how that works?
In terms of process?
And what it actually achieves. Because I think both are important. We need to know how you get there, what you have to do to get it, if the court gives it, and then if the extension is given, what happens as a result of that? What does it mean?
So the order extending the operation of the caveat is simply that. So it's an order generally made in terms that the order will be extended subject to further order of the court. And that order is then taken and lodged with LRS so that the caveat remains on title. That is the interim order that is obtained to protect the position, maintain the status quo, so to speak, whilst any final relief is pursued and dealt with by the court.
I interrupt you. One of the things the court does insist upon is actually running your final relief. So, I'm sorry to interrupt, but you made a point correctly. You don't just go to court to extend the caveat, that's the first step. If a client goes to court, the court will insist that the client runs the whole action. So if you make that decision, you're not obliged to extend the caveat, you can just let it lapse if you want to, and say, oh, I'll take my chances. But if you want to extend it, you're basically kicking off litigation in probably the Supreme Court, or perhaps a district court in due course, usually the Supreme Court, where you seek to vindicate your substantive rights.
And this is a very significant issue for us, for me, as a dispute lawyer. Often a client who has received a lapsing notice will either have been told by someone or will think that all they need to do is go to court and get an order extending the caveat. And that's all they're doing. That's all they're thinking about doing. And so for us, it can often be quite a job to take the client through or manage the client's expectations from that point to the point where they appreciate, as Miles said, they need to not only make an application to obtain the interim relief to extend the operation of the caveat, but also commence proceedings for final relief, which means when we are preparing an affidavit supporting the summons, which kicks off the application, we, as lawyers, need to be satisfied that there is a claim there. And one of the things we need to argue, I think it might be coming across that Miles might get to in a second, but one of the things that needs to be argued on the application to extend the caveat is that there's a reasonably arguable claim. So sometimes it's a bit of a shock for clients when they hear, oh, really, I've got to commence these proceedings that you're telling me are going to cost $500,000 to run over the next 18 months just to get my caveat extended. And that can often take some time to work through. And it plays into the compression of the timeframes in the 21-day period. And on top of all the other things that we need to deal with in order to commence the proceedings and protect the client's position, often we are managing our client through that sort of expectation management process of, okay, I'm gearing up to have the full-on fight now rather than just take this one step and then see what's going to happen. So it's an important consideration.
So from a litigator's perspective, does the caveator have to give an undertaking as to damages in order to have the caveat extended? Miles, can you tell us a bit about that and what that means?
The answer is yes. The court hearing, let me just backtrack a little bit. Justice Stark runs a very, very efficient list. He is acutely conscious of the need within the community for disputes to be resolved quickly. Property disputes are his forte, and he approaches the task explicitly accepting there's a public interest in these sorts of disputes being resolved. Often, fights about caveats can be dealt with very, very quickly. Quickly in two senses. Firstly, quickly in terms of shortly after the application is commenced, because Justice Stark will insist that's done. Quickly also in the sense that he will cut through a lot of the issues. He's a specialist judge doing this jurisdiction. He knows what the issues are. Almost, for most of these disputes, the outcome is fairly predictable. So those disputes can be resolved reasonably quickly. To return to what you said, because the judge doesn't resolve the merits of the underlying dispute, he simply resolves, is there an arguable case in support of the caveat? Do you have an arguable joint venture agreement? Do you have an arguable JVA that has not been terminated? If the argument is yes, he will look to what the lawyers call the balance of convenience. What is the fairer outcome between keeping the caveat on and having it removed? And that's where most of these disputes are about. One thing the caveator must do is give what the lawyers call the usual undertaking as to damages. The court says to the caveator, look, I'm not hearing this case on a final basis. I'm giving you interim relief on hearsay evidence, partial evidence, without hearing all the arguments that will take a couple of years to germinate. The price of that relief is that you promise to pay the registered proprietor or someone who is interested in the property compensation if I discover later on that this caveat does not found, in fact, a capable interest or it should not have been extended. It's what the court does to acquire fairness between the parties. The caveator gets a quick hearing, he or she gets a quick hearing, it's determined on a rough and ready basis, it's determined on materials which may not be admissible in a final hearing. The price of that is the usual undertakings to damages. Now, to preempt perhaps the next question, yes, I've done one of these. I didn't act on the caveat dispute.
which generated the call on the undertaking, but the caveat was extended. The court later rejected it, not because it was faulty, but because on the balance of convenience, the court said there's no need to have it extended. It was removed for that reason. 5 years and about 364 days later, we get a claim for $15 million being a compensation for the sterilised land. Now, just as you won't tell me the outcome of your case, I won't tell you the outcome of my case, except it have ended very happily for my clients after some cross-examination. But people do sometimes invoke this, and sometimes you can predict the consequences. Look, there's a caveat on, I'm going to frustrate this potential sale, this will have some consequences. Sometimes you can predict not much will turn upon the caveat, there's 3 or 4 other caveats around. It doesn't matter if I'm just one of many caveators. Sometimes you just don't know the outcome. And my client in that case was, to say shocked after she got the claim for $15 million would be an understatement. But you have to give it.
So then, Miles, taunted by your response there, tell us about how the application to the court works and whether the court has to extend the operation of the caveat or whether the decision is discretionary. And Gavin, once Miles has done that, maybe you could tell Miles and our guests what happened in our case with the JVA where we went to court.
So what the court does is work out 2 things. First, is there a capable interest? So to pick up the example Peter's been running with, does the JVA indicate prima facie there's a capable interest in the land? That's often the easiest bit because now there's textbooks which categorise interests. You can go 1 paragraph that says option tick, or you have another paragraph, partnership, no, Family Law Act, no, etc. That's the easy bit. Often. Then the court works out the balance of convenience. It says, is it fairer for this caveat to remain on title, blocking other activity, or should it be removed? Now sometimes it's easy to decide to remove it. In the late 80s, builders used to put caveats on under building contracts claiming outstanding amounts due to builders. There was one celebrated case before Peter Young where $4,000 was involved. The judge said that amount of money does not justify a caveat on the land sterilising the property. Sometimes, to pick up where we started half an hour ago, a first mortgagee is owed a lot of money. There's no way the proprietor can pay it back. The court can say, I'm not going to hold up a sale of land by the first mortgagee because a second caveator wants to block the land. If a landowner wants to sell the land to discharge his or her debts, the court will usually lift the caveats and give you security over the proceeds of sale. That tends to be the fight. Does the balance of convenience support or resist the extension of the caveat? Part of that, as I've said, is giving the usual undertakings of damages. The court may impose terms. It may say, look, we're going to extend the caveat, but we want this hearing expedited. We want you, the plaintiff, caveator, to undertake the court to prosecute the case expeditiously and go off to see the expedition judge. So there's all sorts of ways the court can massage what happens. I should say this, the starting point is, if you have a capable interest, the court would assume that it should be extended because an interest in land is usually worth protecting. But that's the starting point. Can I just say one other thing about undertakings of damages?
It happens commonly. I know it wouldn't happen with your firm, Gavin. It's impossible to think. But you go up to court and you turn to your instructor and say, and I assume they give the usual undertakings of damages, and they go, oh, I don't know. It's important you understand that you are giving that undertaking as the price for the extension of the caveat. It's important for another reason. If there is an issue about it, you need to disclose it to the court sooner rather than later. The court will find out about it, usually through cross-examination or the other side's evidence. You need to think, is my undertaking for damages of value?
And just on that point,
Yeah.
the undertaking can be interrogated in terms of the substance behind it.
Yeah, so if you've got a $2 company, the other side will simply do an ASIC search, see you're a $2 company and say, of the caveator, your undertaking is not worth pound and shot. And then you turn to the directors and say, well, can you give a personal undertaking? Or you turn to another company within the corporate group, can you give the undertaking? And those parties should be drawn to the proceedings.
And then that plays into, so the undertaking as to damages is the question in order to obtain the interim relief. But then once you've dealt with that, as the plaintiff, you'll then be hit with a security for costs application, potentially, because the defendants will say, well, we have a concern that there won't be any money if we're successful. So then you need to deal with that. So what can seem like a really good idea to head off to court and seek these orders, from the client's perspective, can become a little bit of a nightmare potentially if they have to give the undertaking, substantiate it, and then once they're through that, then get hit with the security application, along with everything else that's being dealt with, and the discussions around our fees and other things. So there are a number of things that do become relevant and start to compound when you're dealing with these sorts of applications.
So Gavin, our developer client did give an undertaking as to damages in a form that was appropriate for the case. What happened in that case? What was the interim relief, if any?
Well, yes, our client was good for it, so the undertaking was okay. What you haven't mentioned is that at the time that we headed off to court to seek to extend the caveat, we also sought some freezing orders against the defendant and the landowner. That was because we had tried to court win that the landowner was looking to sell the property that was the subject of the caveatal interest. So we was, instead of running the application and having the risk of the freezing order as well, I think the defendant took the view that they would try and sidestep that, so they wanted to negotiate. So we managed to achieve an outcome at that interim stage whereby an amount of money, they tried to achieve an outcome whereby an amount of money was paid to settle the whole case at that point. That was rejected by our client. And then in effect, the defendant rolled over on the application to extend the caveat, and we obtained those orders in a fairly uncontentious, non-contested way. And then we're required to pursue the proceedings for a period of time and eventually resolve the matter with our client getting everything that he was entitled to. So a good result for our client. And if my recollection is correct, there were also some costs that were paid by the other side as well. So not such a good outcome for the other side, in that if they'd negotiated early, then they probably could have got a better result. And our client certainly fell into the category of person who felt that he had tried to negotiate with the defendant, but by the time it got to the point where he needed to pursue an application to extend the caveat and other things, then he just wanted everything.
Thank you, Gavin. So Miles, now that we've told you...
I told you so, I knew you'd win.
So how did you go with your case with the $15 million?
They couldn't prove cause and effect.
Right.
So after 2 days of cross-examination, the case collapsed. But these things, in one sense, I suppose we've been emphasising the difficulties of caveats and the downside. And there's no doubt in all our experiences,
when a client gives you undertakings of damages, it can become an albatross around the client's neck. The client needs to think about it very carefully. Conversely, someone in your defendant's position hates having a caveat on. It sterilises the land. It makes life very, very difficult for them. The financier, the mortgagee may not extend more money. It is a very powerful weapon. It's very easy to launch. I think how much does it cost to launch a caveat? $120 odd, something like that.
I think it's $143.50 now.
Yeah. So it's extraordinarily cheap by our standards. It is a very powerful weapon to plant there. And like I say, if you're in the business of lending money or you're a supplier of goods and you want to stamp on the title your interest at a point in time, it's the best way to do it.
There may be circumstances where the landowner will want to deal with the land in a manner that won't affect the caveator's interest, and in that case the caveator can consider the request and consent to registration of that dealing, and sometimes that happens. It certainly happened in our practice a number of times where we act for acquiring authorities who are looking to get an easement for sewerage or electricity infrastructure over a person's property, and the caveat will sit on title for quite some time until the infrastructure is built and the easement's acquired. And in the meantime, the acquiring authority will allow dealings to happen with the land. So I mention that for the sake of completeness.
It should also be said that often when you are dealing with complicated and multifaceted disputes between parties, and those parties may be involved in the arrangements through a number of different entities, the lapsing notice process is something which can pretty easily and quickly bring things to a head. Now, it may only bring things to a head in relation to one or two entities and a piece of land, but that is often enough to bring the entire dispute into the frame and allow the issues to either be sorted out in some way or at least head off into a proper dispute. Often with commercial matters that are multifaceted and complicated, there will be a bit of a dance going on between the parties involved as to who's going to move first and who's going to be able to protect their position better over a period of time. And so one of the levers that can be used quite easily is a lapsing notice.
So to round off and complete the discussion, there's one more question that I'd like to ask to Gavin, and then we've received a question from one of you who's attended tonight. So for Gavin, just a little bit more, if you don't mind, about the costs, timeframes and proceedings for seeking final relief.
Okay, it's a fairly broad question because it depends on the nature of the claim and the number of parties involved. But as a general rule, if you are heading off to court to deal with or to pursue some final relief, you're looking at least 12 months generally, maybe 18, maybe more depending upon the complexity and the busyness of the court at the time. In terms of cost, in the jurisdictions we're looking at here, generally the Supreme Court, in terms of this discussion, you would be spending at least $100,000 by the time you've dealt with all the things that we've talked about today on an interim basis, and then moving through to your final relief, and more likely multiples of that. So it's not an inexpensive process, and everyone needs to be mindful that if you embark on this sort of a process, you need to have the wherewithal and the preparedness to see it through. One piece of advice I'll give for free is that if you are going to commence proceedings, you need to be committed to them and you need to be prepared to see them through. It's a recipe for disaster to commence proceedings on the basis that you think the defendant will come to the table and talk settlement very quickly and then we'll resolve it. Generally, when you think that, or when the client says that, you know the exact opposite is going to happen. So in terms of the process itself, most people in the room may have a bit of an idea of this. You commence proceedings with an originating process of some type. There will be a defence of some type put on. These documents are called different things in different jurisdictions. Generally, in most courts in New South Wales now, you're not entitled to seek what we call discovery, which is subpoenas or notices to produce or discovery orders until evidence is on, which is quite a big change to when I started practicing anyway. You would get, years ago, cases being commenced where parties waited to get into the proceedings to get discovery and then effectively build their case. You can't really do that anymore. You need to have a case. You need to be able to sign off on it. You need to be able to put your evidence on. And then after the evidence is on, you can then make applications to seek documents in order to fill gaps and holes. So it's quite a different process, I suppose, now. And then after all that's happened, you will then be looking at expert evidence as well, which can be costly and time-consuming to put together as well. Once you have all those things done, then you're looking at the final trial. So, and things don't move quickly in law. So we're talking about 21 days and saying how that's such a short period of time, and it is in terms of preparing cases and running cases. And weeks and sometimes months will pass in the various stages of what I've just gone through in the preparation of a matter for hearing. And then the hearing itself may be allocated months ahead, depending upon the availability of the court. So it's a significant investment in time and money.
The actual caveat dispute is often resolved pretty quickly.
Yes.
That's a matter of weeks, perhaps a couple of months. The long haul comes later.
Thank you for that. We've now come to the question that's been put to us, and that is, can you protect your property by putting a caveat on it as a means for asset protection?
That was a very perceptive question. Can I just give you my simple answer to that? In New South Wales, no, and in Victoria, yes. Actually, a difference in the authority. This has come up in cases where the owner of land seeks to stop a mortgagee sale, alleging that the mortgagee is not exercising the rights to sell appropriately. So it puts a caveat on to try and stop the sale, to say to the mortgagor, the mortgagor says to the mortgagee, you're not exercising your right to sell appropriately. I want to stop you from exercising. I'm putting a caveat on to stop it. In Victoria, because things are different down there, horses go one way around the track, that's a capable interest. In New South Wales, resolutely, because it came from Victoria, the answer is no. And there's a strong judgment by Justice Pembroke to that effect 7 years ago. I think it was a perceptive question, whoever asked it, but in one sense it doesn't matter if it's New South Wales or Victoria. Judges will see that this is a device to protect the property against claims of other people with interest in the land. And the question, is it a capable interest, might be answered affirmatively. If you get a judge who takes a different view than Justice Pembroke, for example. But almost certainly the balance of convenience will incline in favour of the party with the bona fide interest in the property. The mortgagee, the chargee, it will come out in a wash like that. So it's an interesting question, but usually it'll be resolved, I think, on a more practical level.
And I agree with all of that, and I'll say this, more broadly when you're looking at asset protection, if there is an option for a transaction that has taken place to be protected by the lodgement of a caveat on title, and that has the effect, if you like, of protecting some equity in the property from another creditor who may not have yet lodged a caveat but may in the future, then through the back door you may have achieved asset protection. And I have seen situations where related parties to the landowner who is being pursued by creditors has been able to, or have been able to release equity out to a related third party through that sort of a mechanism. Now, there's a whole lot to be said about the bona fides of it and whether the interest or the transaction will be held as legitimate, and whether a trustee in bankruptcy or a liquidator may be able to set that transaction aside as being entered into to defeat creditors. That's a whole separate seminar. But it is, yes, I agree with Miles, it's an interesting question. And if the person who asked it is here and wants to chat about that further, happy to take that up.
Thank you. Are there any further questions that you'd like to ask?
Thank you. May I ask Mr. Condon and his learned colleagues, from the pure commercial world, it's not uncommon in a commercial agreement which has little or nothing to do with land, that party A will require party B to charge whatever real estate of which he may be a registered proprietor of, presently or in the future, with his obligations under this agreement, and in so doing it acknowledges that he is therefore creating a caveat interest in favour of party A. I've seen that many times through the years. I've never been involved in any case disputing such a caveat lodged pursuant to such a provision. Does it work?
It does. It comes up, so I do work for, I say, plumbing suppliers. So in their standard form contract on page 86 at the bottom in Arial font 6, you'll see that sort of clause. Yes. It's usually on page 4 actually. There's nothing improper, indeed it's perfectly valid, to charge present and future property. The law recognises that, and it's very common then for my clients to find a property years after the contract's been executed, lodge a caveat, and the judges, in my experience, have no problems at all about it. Can I just raise one other issue? I think it's now of historic interest only. You used to have to pay stamp duty on charges. That was abolished, I think, in 2015 or 16. There was a whole cottage industry about interested people like me as to whether your charge had to be stamped for it to be effective. Now, I think, so I used to run cases. In fact, I ran, as only a barrister can, in the space of 2 months, the same argument for different sides before the same judge. That's okay. That doesn't happen anymore because most of my contracts now post-date the abolition of... Yeah, but it's a real problem. If it's predating it, you need to think carefully about that because the law may be you can't lodge a caveat. But returning to your question, those clauses are very simple and very common, and they're effective. And just to segue, you often see clauses that say, conversely, you're not allowed to put a caveat on. Those clauses are not valid.
That's against public policy?
No, because the interpretation is someone has a statutory right under the Real Property Act to lodge the caveat, and you can't contract out a statutory right. So, yeah, it's been tried.
Any other questions?
A bit out of the box, because it's not commercial so much, but can a wife who loans money to a husband pursuant to a loan agreement that's legitimate lodge a caveat against the property that the husband buys to protect her interest to have that money returned to her, or to prevent the husband selling the property to someone else and not returning the money to her? The money was loaned, in this instance that I'm thinking about, to pay out a proper mortgagee who wouldn't continue a loan over the property because the husband wasn't in a position to maintain that loan to a proper bank. Is that a proper caveat of interest?
Well, there's two ways of looking at it. You look at the loan between the husband and the wife, and you look at the terms of it first of all to see does it create a capable interest. If it's a simple loan that says nothing about security, the creation of a charge, something like that, the answer to your question is no. I don't think there's any right to subrogation because you're talking about two separate properties, paying out one property and then buying another property. So I don't think there's a capable interest.
There's only one property.
Oh, okay.
Sounds like it's a refinance.
It's a refinance, effectively.
Right. So isn't it, I'm happy looking at it for you. It depends.
It's just an interesting question.
The reason for my hesitation is whether there's a right to subrogation when you're paying out the previous mortgage. That's why I'm hesitating. Normally, a subrogation right will found a capable interest. I do it fairly often in those cases. So that's what I'm lurching slightly towards at the moment.
And no mortgage was taken, by the way?
No. It's an interesting one.
During subrogation.
Thank you.
Thank you very much, ladies and gentlemen. I hope that you've found the evening as enjoyable as we have. We've now come to an end to the formal presentation, but please stay around for drinks and something to eat and to have a chat with us all. We'd really enjoy that very much. Thank you once again.